All righty. I am excited to be able to do this with everyone today. We are going to be talking about taking a better listing, how lots of tips to help you um, do that. I'm getting the chat on my screen. Okay, chat. Where's the chat? Zoom. Give me 1 second. I lost the chat. Where did the chat go? Oh my God. All right, if you have a question, you feel free to unmute yourself and shout it out. I cannot seem to locate the chat feature wherever it went in the in the Zoom meeting. So while I'm on full screen, so today we're going to talk about how to take a better listing. We're going to go through the process, the closing process. We're going to talk about a lot of stuff. My slides will be available to you. You'll see my contact information at the end. Send me an email or a text message, and I will send you the slides after the presentation. If you have questions after the presentation, you can always call, email, text, Facebook chat, whatever it is you're comfortable with. I'm available to discuss anything related to the presentation or closings in general with you. So we're going to dive right in. Now, I'm a lawyer, so we start with a disclaimer. I'm going to be giving you a lot of advice and information, but it's not legal advice. And if you have any questions, you need to consult me separately. A little bit about who we are. We were founded in 2007. We focus on real estate and business law. We have a full service litigation department. We help buyers, sellers, realtors, small business owners, property managers with all their business and real estate needs. And we have offices throughout Southwest Florida. I have been licensed since 2003, which means I am now in my 17th year, which is a little bit scary for me. And I focus on real estate and business transactions. I am a recovering politician, so you have to excuse the jokes. Let's jump into what we're going to talk about today, the substance. We'll talk a little bit about what the title attorney does. We're going to go through the title process, taking a listing and contract to closing. So you'll see basically what's going on in the background after you take sign a contract and some of the things that'll help you get a better listing because you're going to know the whole process from start to finish. And really our goal here is to give you like a 360-degree view of the process from listing to closing. I think a lot of realtors, they know how to sell property, but they don't know what happens after the contract closes, and then they get frustrated by the process of closing. And so this should give you some information and shed some light on why we're asking you certain questions and why information is needed. Let's start off. What do we do for you? Well, once the contract is signed, we handle the rest. And what we're doing is we're managing deadlines. It's all about getting things done on time. We're negotiating inspections. We're dealing with loan commitments and short sales. And then, of course, we get the closing done. And we're clearing title, looking at everything on the title and getting it going. So after the sales contract is executed and delivered, and of course you all know under our NABOR and FARBAR contracts, delivery is important, we begin the title process. We coordinate the interests of all parties to the transaction, make sure everybody is on the same page. We're kind of the middle of the circle, so to speak, with lenders and sellers and buyers and agents and inspectors and surveyors and everybody else. And we make sure that all the requirements for settlement are fully satisfied. So I'm going to take you a little step by step through the title process so you know what's going on in the background. And then again, if you have questions, you should feel free to jump in at any time. So step one is the title search. You send us your contract. We start researching the title. We look through the history and its ownership and make sure that we're looking for any claims of liens, outstanding titles. And our goal is to get your buyer marketable title. Marketable title. That's the key. We deal with the survey. Most lenders require a survey, and we order a survey. We get the proper certifications on the survey, and then I personally review each survey to make sure that if there are any encroachments or encumbrances, we can deal with them in a timely fashion under the contract's terms. We make sure the taxes are paid. Very important. Taxes are a super lien. A tax deed would pretty much wipe out the lender and anybody else, so we make sure the taxes are paid. We check that the utility and association bills are current. We go through, we order estoppels, we do lien searches, we make sure the utilities are paid, all the association dues are up to date, and that ever important association estoppel is secured for the buyer. And of course, we issue a title insurance policy. We have a title insurance commitment, and we issue owners and lenders coverage. We do the loan documents for the closing. So we're working with the lender throughout the process to get everything organized on their end. Yes, I hear a question. All right. Oh, somebody just jumped in. Okay. Once we review all the loan documents, of course, we bring you in for closing. And of course, at closing, I sit with the buyer or the seller, and we go through the documents, make sure everything is taken care of. And then after we're closed, we disperse the money and we pay everybody and make sure that everything is properly recorded, that mortgage liens are released, and we send everything back to the lender. And I said recording, we talk about everything gets to the courthouse in a timely fashion, and we follow up on all releases. So before I go into a few red flags that you need to be really aware of in your closing, in your process, does anybody have any questions on the process so far? Okay. Again, I can't see the chat for whatever reason. Zoom is not cooperating, so you've got to speak up. Okay, let's talk about some of the issues, the red flags. When you use an attorney, you get a lot more than just a regular title company. Of course, if you use my title company, I'm involved in paying attention anyways. But one of the services you get with an attorney is looking for issues that will delay closing. Of course, nobody wants their closing to be delayed. So in our office, we're working to resolve the issues, and we keep the closing going. Let's talk about some of the specific issues that you got to look out for when you're taking your listing, because I'm looking out for them when I'm doing your closing. You've probably seen all these: divorces, bankruptcies, foreclosures, recent marriages of either party, liens or judgments against the seller, deaths of the property owner, or easements that are out there. As a matter of fact, I just had an easement issue. A realtor called me up and said, hey, I'm selling this piece of land in the estates. It has a dirt road connecting to it, but it doesn't touch the main road. What do I do? And we went through the process, and lo and behold, we're going to have to get some easements from some neighbors to the main road. Divorces, that can be very complicated. We're going to talk about that in greater detail in a few minutes. Foreclosures, if it's been through foreclosure, we have to make sure that that foreclosure was done correctly. Recent marriages of the seller or the buyer will affect how homestead works, either on the seller side with selling the property and who has to sign the deed, on the buyer side with who has to be on the mortgage. And those can be some pretty sticky questions for some of your customers. So making sure that and we'll talk about this again in detail, making sure you understand their status and who has to sign what is going to be very, very important. Other issues we deal with: encroachments, not being present for closing, doing a mail away and timing that out, working with you, the realtor, to meet your customers' expectations for getting documents signed is very important. A lot of times we don't have control over that because the lender is in charge, but we do our best. When a power of attorney has to be used, we're going to talk about that in detail, but just know that 2 witnesses and the notary is the key there. If a trust is involved, making sure we have the current co-trustees or individual trustees involved. Of course, FIRPTA, I teach a whole class on FIRPTA for foreign sellers. So that's important. And then of course, the Southwest Florida, you know, we have an elderly population. So we're always looking at guardianship issues, incompetency of the seller and who can sign for them. I deal with a lot of that, unfortunately. And then of course, association liens, making sure that you're current on the association is a big part of our process. Any questions so far on the red flags? Nobody? Nobody wants to shout out a question? All right. So let's talk about taking that listing. What can you do to make the listing process go more smoothly? Before you even go on the listing appointment, take a look at the prior deed. There may be a link in the MLS, or you have to go to the property appraiser's website. So important, the prior deed. It tells you who you need to deal with. And if there are multiple people on the deed, there's going to be multiple people on the listing agreement and multiple people on the contract. So make sure that we look at that prior deed. Glance at the public record. Go through the clerk's website. You can search the names of the seller and see if they've got a mortgage, if they've got liens, if there's been any judgments against them. You can look for ex-spouses and deceased parties. If there's an LLC owner, you see who signed before. If there's a trust, same thing. Again, if there's a power of attorney, you're looking for all that in the public record, because you're going to have to know that, because you want to make sure the right person signs your listing agreement. And then one thing I always tell my realtor partners, I always say, if you pre-fill and pre-deliver the listing documents and the disclosures before your listing appointment, you look great and you look prepared and you look researched, and everybody feels good about it. And I'm happy to help with any of this, by the way. I should say that from the beginning. If you ever have a question, you look at a listing or a potential listing and you want information about the trust or the LLC or anything, I'm happy to help you research that. I don't charge for it. Usually takes a few minutes, but I'm happy to do that for you. Okay. So when you get to the listing and you have given the pitch and you look great and everything is wonderful and you get the listing, the seller is going to sell with you, what is the next step for you? Of course, you're going to do your pictures and you're going to do all your stuff to get it going for the marketing. There's a few things you're going to want to do to make your closing process go much more smoothly, because you're going to get a contract. It's a hot market. Do this. Ask your seller for the following. Get the prior title policy. Of course, under the NABOR contract, the seller has to provide their prior policy or they're dinged $150 for the title search. You know, this solves a lot of issues that could delay the closing. So it's a very important document. You know, and I would just ask the seller, hey, listen, when you bought this place, your title company probably gave you a package. May I just take a look at that? And then from there, you can get usually the survey, ask them for their mortgage statements, ask them if they have a second mortgage or a line of credit. And then, of course, ask them for the association information. You know, this association, if they're in a condo or an HOA, you've got to provide that prior to signing the contract or at the time of signing the contract. On the HOA side, you know, to avoid the 3-day right to void the contract, and on the condo side to start the 3 days so that you can make sure that you have a deal. So ask your seller, once you've got the listing, who do they pay, get their statement so you can make a proper HOA disclosure. Look for master and local associations. And again, get those association documents for the condo because there is a 3-day right of rescission. Other things you have to ask your seller for, and this can get a little uncomfortable. Someone has passed away, you got to get the death certificate, or we have to get it. Powers of attorney, trust agreements, the LLC operating agreement, which we're going to talk about that in detail. And then, of course, leases, if it's an investment property. Just ask your seller for all this stuff. Okay. So let's talk in detail now about, before I do that, does anybody have questions? Sorry, I don't want to go too fast.
Yeah, Sam?
Yes, Dan.
Yeah, the survey, for example, if the survey is 5 years old, is that still good or does it have to be newer?
So we have a lot of conversations in our office about surveys. I think a lot of title agents do. The answer to your question is, if the survey is certified to the seller and the seller can sign an affidavit that says they've made no changes to the exterior of the property, then we need the survey, and we would encourage the seller, because the contract requires it, to sign a survey affidavit. If the seller, if the survey is not certified to the seller, but is certified to someone in the prior chain of title, technically the survey is usable, but I would always advise my seller client not to sign the survey affidavit and to tell the buyer to get their own survey, because you can attest that there's been no change if you didn't own the property during the entire period that the survey was from the time the survey was drawn until the close date. So
Okay.
it's a complicated answer, but always get the prior survey because it gives us information that we can use to move the closing along faster. Even if we just give the survey to the new survey company and say, here's your starting line, get us a new survey. It's a very helpful document.
That's a seller's expense if there's no survey?
No, I'm under the FAR/BAR and the NABOR contracts. The survey is a buyer's expense, but the seller has got to fix encroachments.
Okay, thank you.
You're very welcome. Anybody else? Questions about the survey, documents that you should get?
Yes, I have a question on the title policy. Is
Yes,
there
sir.
age limit on the age of that policy?
No. Title policies last for the life of the owner and their heirs, so there is no age limit. They show us, they take a picture of the property as of the date of the title policy and protect everything backwards, so it really should be no change. So the short answer to your question is no. We always need the prior policy. Anybody else?
Sam,
Yes, Frank.
I had a question on the association docs.
Sure.
So I just got a contract yesterday and I sent the other agent all the docs and everything. Do I have to give the buyer that piece of paper that says you pay $1,285 per quarter, and do they have to sign that, or are the docs enough?
Is this a condominium or homeowner association?
Condominium.
Condominium, you do not need the piece of paper that says the association dues on it. You need a receipt from the buyer saying they have received all of the documents listed on the condo doc receipt, which is a NABOR form.
Got it. I know what show form that is.
Yep, and then the buyer has 3 days to review everything you've given them and 3 days to terminate.
Okay, and how do I get that form back if the other agent drags her feet or doesn't, send it to me within the 3 days? Just ask for it.
That's a very good question. It's a tough question because the statute simply says you have to deliver it as the seller to the buyer. It does not say the buyer has to acknowledge receipt. So I would send it through an email with a return receipt request or fax. You can't fax the documents, there's too much, but send them in some fashion that you get a signature if you FedEx the originals. But as the seller, you do want some proof from the buyer that they received the documents to get that 3-day clock ticking. And by the way, the statute says buyer, not buyer's realtor or agent or other. It says so just because you've delivered the documents to the selling agent does not mean you, the listing agent, have completed your job. You've got to get the documents to the buyer, obviously through the selling agent, and get that receipt signed. If they won't sign the receipt, then we have a bigger problem.
I understand. Thank you, Sam.
You're welcome, Frank. Anybody else? Okay, I'm going to move on. Let's talk about limited liability company as a seller. Two documents control LLC operations: the articles of organization and the operating agreement. These two documents, it's kind of like the Constitution and the Declaration of Independence. The articles of organization declare the existence of an LLC, and the operating agreement tell us who's in charge, who signs what can be done, who can sell what, and how. Very important that we have both of these documents in the package when we get the contract, or shortly thereafter, because we make sure everything is valid. Let me tell you a little bit about LLCs. There are two kinds of LLCs in Florida. There are manager managed and there are member managed. Under the manager managed, the manager signs. Very easy. Under the member managed, the members sign. And in absence of something in the operating agreement to the contrary, all the managers or all the members have to sign the closing documents. So that can be difficult when parties are fighting and one manager wants to sell and the other one doesn't. So we need to look at that operating agreement carefully and see who has the power to sign. Again, the power to bind the LLC. I will also say this about LLCs. There is no such thing as the managing member. If you see managing members of your LLC, you have a member managed LLC and all the members have to sign. If we don't have an operating agreement, which many LLCs do not have an operating agreement, then we do what the articles say. And if it's unclear in the articles, if they didn't specify member managed or manager managed, everybody signs. That's unfortunate, but that's the way it is under Florida law. And but one nice thing about Florida law is you do not have to register an LLC to transact business in Florida. You can have your LLC in Delaware, Idaho, any state, and you can own Florida property and sell Florida property without an issue. One other thing I'll talk about separate from LLCs is foreign corporations, international and domestic, have to record everything in the public record in Florida. So it's a little different than the LLC. So if you see an Inc., whether it's a Florida Inc. or I'm sorry, a corporation out of another state or another country, they've got to record all their certified copies in Florida. And that can be a time-consuming process. So we want to make sure we get on that early. All right, before moving on, does anybody have any questions about LLCs?
Hey, Sam.
Yes, Maggie.
I have a quick question. So if you're, say, for instance, on the purchasing side of an LLC owned property, I mean, every title company should be making sure that they have all of the operating agreements and that all of that's in line, or would you say that some of them could drop the ball on that?
Well, you said purchasing side, so let me clarify. You mean when you have the buyer and you want to check on the seller's status, or the buyer has an LLC?
When we're representing the buyer and we're checking on the seller who has an LLC.
Yeah, so your title company, whoever you're using, needs to make sure that the correct parties, they need to examine the articles of organization, the operating agreement, make sure the correct parties are signing. And really, it's the listing agreement that needs to be signed correctly, and the contract and the closing documents. Because, for example, if you have two managers of an LLC and only one wants to sell, say it's Bob is here in Florida and you're talking to him about selling his rental property, but John is up north, his partner, and doesn't even know or want to sell. You could have a major problem if you signed a listing agreement with Bob and not Bob and John, and Bob didn't have the power. Now you just spent all that money on marketing. You've sold the property. You're expecting a commission. but you don't even have a valid listing agreement because John has no obligation to pay you. What you have is a lawsuit against Bob, which is terrible. So understanding that process really from the beginning, and then of course making sure that your title company knows what they're doing on this issue is super important. Other questions about the LLC? Okay. Let's talk about trusts. Trusts do not hold title to real property in Florida. What? What about all those trusts? Trustees hold title to real property in Florida. So be very careful. You may have a title problem on your hands when you go to the callyourappraiser.com and you're looking and it says the Bob Jones Trust, UDT, and then there's a date. There should be a trustee somewhere. So you have to look at the deed and make sure that there's a trustee named. Otherwise, you've got a title defect from the beginning. So that's one issue that I always counsel folks to look on. And we, of course, again, we're looking for who has the power to sign for the trust. And one thing that you can look at when you're looking at that deed for your seller, if the section 689.073 trust powers are in the deed, then we may not need to deliver the trust agreement. We may just be able to use the information from the deed. However, if there are successor trustees, we probably have to look at the trust agreement. If there are co-trustees, we may have to look at the trust agreement. So when you're talking to your seller and you're in that listing appointment and he says, well, I don't need to give you my trust. You say, well, you know, unless you're the original trustee and there's no co-trustees, it's probably best to have the seller take a look at the entire trust document to make sure that it is what you're saying is accurate. And just so you know, the trust powers that you're looking for in the deed are the power and authority to protect, conserve, sell, to lease, to encumber, or otherwise manage and dispose of the property. So that's the wording that you're looking for in the deed. Okay, any questions about trusts? I know you all probably see a lot of trusts here in Southwest Florida. Any questions? Okay. Barbara?
Yes.
Did you have a question?
No, I'm just switching from my laptop to my car. Sorry.
Okay. Let's talk about signing with the power of attorney. A lot of powers of attorney used here in this market because of the age of the population and the fact that some of it's somewhat transient. If the seller is signing with the power of attorney, they've got to comply with Florida law. That law changed in October of 2011 to say that now you must have the formalities of a deed, which means 2 witnesses and a notary on Florida powers of attorney. If your power of attorney is from a different state and it does not have 2 witnesses and a notary, it may still be valid, but we need an opinion letter as to its validity from an attorney in the state where it is supposedly drafted. Just remember that durable powers of attorney survive incapacity. So if your seller, say it's a husband and a wife, and the wife is in a memory care facility up north and can't sign, because of COVID or whatever, but the husband is down here and has her power of attorney, and then she is were judged incapacitated for whatever reason, he could still sign for her if the power of attorney is durable, and it has to say that, and usually it will reference the Florida statute for durability. If it doesn't, we may have an issue. We may have to do a guardianship, which is an awful result because that takes a while. And again, we must have the original power of attorney for closing. So let me mention a couple of things about powers of attorney. If you don't have a power of attorney set up and ready to go, it's probably not a good idea to get one. Why do I say that? Because the power of attorney has to be executed with the formalities of the deed anyways. You've got to find a notary. You've got to have 2 witnesses. We need the original. It's just as easy for me to prepare the deed and the closing documents as it is for a power of attorney and then prepare the closing documents later. So usually if someone says I don't have a power of attorney, or I'm up north and I need help signing documents, we just do a mail away. It works the same. So if you've got a situation where someone is going overseas and they're not going to be available to sign, or I've had this situation where the person was on their deathbed, they were in hospice, and we just needed to quickly get something done, and they had a power of attorney they could sign. We did that. But normally we would just send the closing documents. All right, questions on powers of attorney? Everybody understands powers of attorney? You got it all? Okay, let's keep moving. Divorced parties. So notice divorced. If you are divorced, we have to examine your marital settlement agreement if the other spouse is still on the title. And we may need an affidavit or a quitclaim deed to complete the marital settlement agreement requirements. Now, this is very complicated because you as the realtor have to help facilitate this process from the beginning. Someone tells you they're divorced, you got to have the conversation. Okay, we can get this property sold for you. The title company is probably going to need to see your marital settlement agreement. Do you have a copy of it? Do you know, is your spouse on title still? A lot of times, you know, these divorces were hung over from the financial crash, 2008 financial crash, and they couldn't refinance to get the other spouse off. They couldn't get it sold except because of a short sale. There was a bankruptcy. Lot of family and just financial issues that came out of that, as we all know from living through it, one of which is incomplete divorces. And we see it all the time. And if you have an incomplete divorce where they didn't complete all the requirements of the marital settlement agreement, or the divorce judgment does not clearly and unequivocally pass title from one spouse to the other, then we're going to have to do a couple of things, including examine the MSA, and we're probably going to need an affidavit or quitclaim deed from the other spouse. Now, that's divorced parties. How about divorcing parties? Other spouse will need to sign if homestead or marital property. That's the way it is. Florida does not recognize separations. You are either married or not married. So that's an important issue. Couples are fighting. They're trying to get their assets organized. They're going through a divorce. They're selling properties. They're doing other things. They're having problems. It's a sticky situation again. But and they're saying they're separated. They may be coming from up north where they have a separation agreement. Some states recognize separations. In Florida, they're married, and it just has to be dealt with. You know, I don't want to toot my own horn, but I'm pretty good at solving those problems. My staff is excellent at it as well. So if you ever have a question about that, please give me a call right away, and we will jump in and help out. Okay, before I move on, does anybody have questions about divorce or divorcing parties? Anybody? Anybody? Okay. So let's talk about from contract to closing. What can you do to make the closing process go smoothly? And really, it's everything that we've talked about. Once that contract is signed, deadlines, the clock is ticking. Get all this stuff to the closing agent as soon as possible. All the contract pages, the powers of attorney, the death certificate, the trust agreement, contact information for the parties, prior title, if you've got it, a survey, mortgage statements, association information, the leases, and then of course the commission information. Please get us that right away so we can do our draft closing statements. And then the seller and buyer information form. If you go to sodlegal.com or paradisecoasttitle.com, you can do the buyer and seller information forms. They're online. And it's a very easy process. Okay, so your closing package, when it comes to your closing agent, really you want the again, all this stuff with the name of the association, the contact person. And we ask all this, by the way, on the information form so we can get the information from the seller directly. It's just that, obviously it's very important. Now, I will say this about the association application. I get this question a lot. The FAR/BAR contract says the seller shall initiate the approval process, which to my mind means the seller should give the buyer the application and the association documents that they got from the management company, because a lot of management companies won't talk to realtors and they won't talk to buyers, but they will talk to sellers because the seller is their customer. Make sure you've got your power of attorney, your death certificates, all this stuff. Again, we have to have that original death certificate and the original power of attorney. And if it's out of state, we may have to order it. Other stuff looking at here, we need the commission verification forms signed by both parties, by both realtors, and the same day pay form. My office will do same day pay for realtors, which means we will pay you at the closing table if your broker allows us to. I think that's a big deal in terms of service for you. We follow the Attorney General opinion that says that if we enter into an agreement with the broker and they provide us the required information, we can cut you a check directly. I know how important it is to get you paid, so we try to do that as fast as possible. And then, of course, the buyer and seller information forms are very comprehensive forms to help your client get all the information together. Again, they're available on our website. Questions about getting the contract ready for closing? Anybody? Michael?
Sam, can you repeat the websites again, please?
Yes, sir. You can go to sodlegal.com, and that's going to be on the last page of my slide presentation, or you can go to paradisecoasttitle.com. And on paradisecoasttitle.com, you can actually fill out the information forms online and submit them securely.
Thank you.
You're very welcome. Let me talk here just for a minute about, the fact that we are a resource for you. Got a question? You should give us a call. Really, anytime. And what we need from you, the more information, the sooner the better. Learn the red flags, and I say this to everyone, tell me about your deal early. If you get concerned, you have a concern about something, just give me a call. Every legal problem can be solved with time. We can figure it out. We can do it. So just a thought for you here in closing. What should you demand from your closing agent? Well, these are the things that I think you should demand. Your closing should be done right and right away, not delayed. And a question you can do, test your title agent that you're currently using on. When do they order their title commitment? This title commitment document is so important. It tells, it's the Bible of the closing. It's the checklist. If they don't order it immediately because they want to save a buck, because they're concerned about you not, your closing not going through because of inspections or financing, and they wait, they've delayed your closing and done you a disservice. In my office, we order the title commitment right away, and we start the process right away. We're just big enough that our underwriter gives us a break. If you cancel, there's no cost to the buyer, but we're small enough that you can call me anytime you want, and I'll walk you through the closing process, anything you need. You need regular communication and early notification, and that's what we do. If we have a problem, we're going to say, here's the issue and here's the solution, and we will work with your customer to get it done. And with that, do I have any questions? No questions? Everybody's got it?
I have a question. It kind of goes back to a trust situation.
Sure.
The house was originally a joint tenant situation.
Okay.
One of the owners passed away. Then it went to the surviving survivor. Then that was put into a trust. That person shortly after passed away.
Okay.
So we're both passed. Now it's gone to everything's going to the sister in Michigan. And so I guess she will, I'm a little concerned. Maybe it's
Sure.
something too I might need to just give you a call and discuss. And
Definitely, Greg. Yeah, this sounds like we've got a successor trustee situation. If the trustee has passed and the beneficiary has passed, we've got a successor beneficiary situation. So that's absolutely something you need to get a copy of that trust agreement and those death certificates, and you and I need to sit down and have a more detailed conversation.
yeah,
I'm happy to do that. Again, I don't charge for it.
okay. Yeah, this all kind of was rather, the trust just got, I saw where it had just had filed on the, with the Lee County property appraiser, and then in November, but then he passed in December, like the 10th of December. So now at least it got done, and that part, it wasn't still in the midst of that.
Sure. So that is definitely a situation where we need to sit down and have a more detailed conversation. Okay, folks, I just took us out of screen share and the chat showed up. And so I see a lot of questions. Let me just go through these real fast. So the listing agreement, Deb, you asked about the listing agreement and the governance form. The governance form is available in Form Simplicity and your other forms programs. And that's got to be provided with the condominium documents. So make sure that you just download that and send that with your contract, and have your buyer sign off on that when they get their contract. Then you asked Deborah Brown, what do you have to find encroachments on survey during the inspection period? So no, you do not. During the inspection period, looks for problems with the structure and things like that you're familiar with. The survey has to be ordered and submitted to the seller with encroachments at least 5 days prior to closing, and then it's treated as a title defect. So it's a different process than the home inspection. And then what items in addition to the physical inspection of the home should be handled during the inspection period? Well, the inspection period is for the physical inspection of the home. So that's really all that you need to handle there. And then normally we do not have buyer contact info, just agent info. Yes, when you're taking a listing, you want your seller information. And then of course that's the focus today. But when you'll communicate with the selling agent to get all the buyer information. Can an attorney handling probate for a seller dictate the broker use FAR/BAR listing agreement instead of the broker's own listing agreement? Well, the PR, actually, that's a great question, Allie. The PR is the seller at that point in the probate. So yeah, they can say, no, I want to use a different form. And if they're being advised by their attorney who's familiar with the FAR/BAR form, that's a very real possibility. Let me see here. I represent the buyer, and the buyer just informed me they want all the paperwork put in their son's name. Can I just do an addendum to change the purchaser? Yes, you can. It's a cash offer. I can't read your name here. Why isn't this working? Yes, you can. It's a cash offer, so that's fine. If the seller,
Sam?
yes, Therese.
It's Therese. I'm sorry. Quick question. So don't you have to show like the funds that are in the bank like for 60 days for a paper trail? Do you know what the time frame is?
That's for, you said
parent,
cash. And that's
yes.
for financing.
Oh, okay.
Yeah,
no problem.
If you're financing and the parents are going to provide like the down payment or something, they have to sign a gift letter and you have to do proof of funds. It's a very arduous process, well, that you have to go through it.
Yeah, like in this situation, it's, I gave them the proof of funds from the parents' bank account. So do I have to provide another proof of funds showing that it's in the son's account?
I would ask your sellers, your listing agent, what the seller is looking for and what their expectation is. There is no requirement to do
Okay.
proof of funds in the contract. It's something that people just
Okay.
do by custom.
All right, awesome. Thank you so
welcome.
much.
Okay. Linda, what about disclosure if the seller fails to provide or is uncooperative? Example, lead paint concealing a defect. So that's an excellent question, Linda. Couple of thoughts about it. If the seller is refusing to provide disclosures, they are not required by law to provide, the seller disclosure form. But it's funny you asked this question. I happen to have read Johnson v. Davis again this morning. Johnson v. Davis is a very important court case that every realtor needs to know about. What it says is that sellers must disclose all known latent defects which materially affect the value of the property. Sellers have to disclose latent defects, hidden defects that materially affect the value. Little $2 missing screw, probably not going to affect the value. You painted over the mold with 3 coats of paint and are hoping to get by, but they won't show through before closing. Major defect problem, seller is liable. And by the way, it's not a contract liability, it's fraud. It's a fraudulent misrepresentation, which means you might have a punitive damages issue if you're not careful. So it's a major issue for sellers. They can get really penalized for not disclosing latent defects, especially stuff that they've fraudulently concealed. And by the way, as the realtor, you're separately liable for that. If your seller says, yeah, don't worry about that mold over there, I'll have that taken care of before closing, you need to know what they're going to do. If they're going to paint over it and you know about it, you have to disclose it, whether your seller wants you to or not, or you get sued separately. So be very careful about that sort of thing. Okay, other questions? Anybody? Any questions? All right. With that, I'm going to say thank you very much for your time today.
Thank you.
Let me do this one more time. I'm going to put my email in the chat and my cell phone number.
Good
Tim,
job.
will we be able to get copies of this slide?
Yes, if you send me an email to that email address, of course, I will absolutely get you slides right away. Just shoot me a quick email or a text with your email address and I'll send them over.
Thank you.
Thank you all very much again. And that's a wrap.